Hello, welcome to our session, Three Thoughts on Estate Planning. I'm Sally Baker, Senior Director of Plan Giving for the University of Michigan. A couple housekeeping items before we begin, in case you didn't see the video. We'll answer questions in the last portion of the webinar. You may type questions during any point in the webinar by using the Q&A feature at the bottom of your screen. Live captioning is available for today's presentation. To view captions, please click on the live transcript on the lower right portion of your screen and then choose Show Subtitle. I'm pleased to introduce our speaker today, my colleague, Donna Snyder. Donna joined the University of Michigan's Office of Vice President and General Counsel in 1997, and she is Associate General Counsel. Her practice focuses on charitable giving, which includes tax, estate planning, and other areas of the law. She assists fundraising professionals and others at the university with the legal, tax, policy, and due diligence issues of giving charitable gifts to the university and drafts agreements for major gifts. She works with current and planned gifts, including gifts of various assets, particularly those that are difficult to value or have unusual characteristics. She assists in all aspects of making gifts acceptable to the university, including negotiating gift agreements with donors' attorneys, assisting the university in adopting policies regarding charitable gifts, and other matters related to donating to the university. Prior to joining the university, she was trust counsel at Fifth Third Bank in Cincinnati, Ohio, where she advised trust personnel on fiduciary law issues, including matters related to trusts, estates, investments, and charitable planning. Donna received her law degree from the College of William and Mary in Williamston, Virginia, and her bachelor's degree from the University of Akron in Akron, Ohio. Now, without further ado, I give you Donna.
Thank you, Sally. Many people have been updating their estate plans this past year, or at least thinking about it. And when you are changing or doing your estate planning, you might consider the thoughts I will share today about designating beneficiaries, choosing who controls your finances, such as your trustee or your executor after you're gone, and making charitable bequests. My intent is not to advocate for any particular method, individual, or entity, but just to present you some ideas. Also, there aren't any tax issues in the three thoughts that I will be discussing, so I don't have any more insight than anybody else on what tax matters might occur, changes, and so on in the future. So I won't really be discussing anything related to taxes. So let me get started by sharing my screen with the PowerPoint. Whoops, sorry. There we go. Let's start at the first slide. Okay. And the first thought I want to talk about is designating beneficiaries. Designating beneficiaries is as important as getting your estate planning documents drafted. If beneficiaries are not properly designated, your whole estate plan could fail because it doesn't do what you want it to do. So let's discuss an example, or I'll give you an example that we can then use when we discuss it later. Let's say you have two children. One lives out of state and you see that child maybe a couple of times a year. The other child lives nearby and you see that child more often, and in fact, let's say she helps you with a lot of things, your appointments and maybe some of your finances and other things. But let's say you'd like to treat them both equally at your death. So when you prepare your estate plan, you set it up so that your will, your trust, beneficiary designations, whatever you have, has everything split half and half between the two children. All good so far. Time passes and later you decide that it would be a lot easier if the child who helps you can directly access a couple of those accounts. So you add your child to your checking account and your taxable brokerage account, making those accounts joint with you and your child. What have you just done? Well, you've given that child current and future ownership in those accounts. The consequences of that ownership is that the checking account and brokerage account are no longer in the calculation of 1/2 to each child after your death. That's great if you intend that to be the purpose and that to favor one child in that way. But if that's not your intent, especially if there's a lot more in those accounts, then removing them from the total calculation really favors the joint owner child, right? And the other child might not look so kindly on the sibling. Worst case scenario, might sue the sibling, claiming she took advantage of you. So the result is exactly what you were trying to avoid by all your planning to divide all your assets equally between the two. Instead, your assets are unevenly divided, right? Worse, your estate might be litigated in court, and relationships between your two children might be damaged because of it. So I'll talk about what you could have done differently, but first, let's go over different ways you can designate beneficiaries. The first type of beneficiary designation I want to talk about is an estate. So estate actually is one of those words that has a couple of different meanings. It means all of your assets, but it is also a designation or lack of one. Property that is designated to your estate or is undesignated passes through your will. And for example, a couple of more common types of property are a car that you solely own or a checking account that you solely own. Those would be included in your estate and pass under your will. Also, you may actually see estate as a beneficiary of some assets. For example, a retirement plan when the owner has not designated a beneficiary. The custodian has to put something in that retirement plan, and their default is estate, your estate. So when assets pass according to your estate, they are then devised according to, as I said, the terms of the will, and that makes them subject to probate because wills are overseen by courts. That's what probate is, the process of a court overseeing assets and the proper disposition of them. Courts also probate intestate estates. That means there's no will or other designation, so everything passes according to the law. There's statutes that designate how things go. The next type of property ownership or beneficiary designations I want to talk about is joint ownership. That's exactly what it says, right? It means that all owners have full ownership in the asset. And each owner has the right to dispose of all of that asset during their lives. So all owners have the same rights at the same time. Once someone is added to an asset as a joint owner, they can be removed only with their consent. When a joint owner dies, the survivors continue to own the asset. So it just passes in accordance with the joint ownership and not in accordance with your will or anything. So that asset, a joint ownership asset, is not subject to probate. And when the last owner dies, then the property is disposed of according to the will of the last owner, or the maybe there's been another type of designation. A typical example of joint ownership is between couples, right? So husband and wife often have joint ownership of their homes and maybe some bank accounts or other accounts. The next type of beneficiary designation I want to describe is a transfer on death. Now, these mechanisms allow owners of certain types of assets to contract with the asset holders to designate beneficiaries. The beneficiaries don't have any rights. Only the owner has all the rights during the life of the owner. So the owner can change the beneficiaries at any time, can do anything with the asset, add or subtract from it, whatever, without the consent of the beneficiary, except for certain retirement plans. The beneficiaries become owners of the asset after the death of the original owner. The assets are not subject to probate, although they could be subject to the rights of the decedent's creditors. Two of the most common contracts that include transfers on death are retirement plans and life insurance. I mean, life insurance is set up for beneficiaries, essentially. State laws may also allow other types of assets to be transferred, like maybe securities. You'd have to check your state law to see how that would work out. So the last type of beneficiary designation I want to talk about is a trust. A trust is an entity with its own tax status. Assets owned by a trust are distributed to trust beneficiaries according to the terms of that trust. Since a trust is its own entity, it's best to have an estate planning attorney draft a trust for you. If you don't already have an estate planning attorney, a good resource for finding one in your area is the American College of Trust and Estate Counsel, known as ACTEC, A-C-T-E-C. ACTEC's a national organization, and the attorneys who are ACTEC fellows are chosen by their peers as the best trust and estate attorneys. So it's a very good organization to try to find someone. I think our friends are putting ACTEC's website, actec.org, in the chat or wherever, so you can see that if you need it. Now, there are different types of trusts, and the Revocable Living Trust is the most common and has the most flexibility. You can be trustee until you're unable to act, and then the trust would be taken over by a successor trustee and continue until its own terminates by its own terms. So you can fund a revocable living trust during your life, another good flexible thing, and use distributions from it to take care of you, including if you become unable to handle your own finances. So then the successor trustee would handle them. Or you can leave it unfunded during your life and designate it as a beneficiary of assets at your death. Note that trustees have authority only over assets actually owned by the trust. So if you want your trust and a successor trustee to take care of your assets when you become unable to, you have to put the assets in the name of the trust to make it the current owner during your life. That's known as funding the trust. You can put some of your assets in or all of your assets in, however you want to do it. If you only put some in, then you can designate the trust as the beneficiary so that they're transferred into the trust at your death. And this is very useful for retirement plans when you can't change the ownership of the plan during your life, otherwise there would be tax consequences. In that case, you would make the trust the beneficiary of your retirement plans. And if you want to do this, I caution you to definitely get an attorney who knows this area of the law to draft the trust for you and advise you, because the whole retirement plan could be taxed at your death unless the trust is done correctly. And make sure you actually designate the trust as beneficiary, or what I said at the beginning may occur, that you will have a well-drafted trust that doesn't do anything because there is nothing in it. I have seen that happen before. After your death, the trustee will distribute assets according to the trust terms. And here's where there's even more flexibility. So the trust, like transfer on death, can distribute assets to the beneficiaries, right, at the owner's death. Or the trust can be set up to let the assets stay in the trust, so the trust continues to be owner, and then they are distributed over time. For example, parents might want assets distributed in portions to their children, like 1/3 at age 25, 1/2 at age 30, and the rest at age 35, something like that. So let's go back to our example and see what could have been done differently. When you make your one child joint owner or beneficiary of more assets than the other siblings, it is best to calculate how it will affect your whole estate plan. So make him or her the owner of more assets, because that is the result that you want. You're doing it on purpose, not just because joint ownership is convenient at the time. It's also best to inform your other children that you're doing it and your attorney, because the attorney might want to have some kind of writing that indicates what you're doing and why. Alternatively, if you don't want to leave more to one child than the others, you should consider other methods of allowing that child to help you without making a joint owner of that one child. For example, you can create a trust and fund it, a revocable living trust, and fund it and make your child trustee. She can manage the assets in the trust during your life, distribute them to you during your life, take care of you, and then after your death, she would be responsible for distributing the trust according to its terms. Or you can give your child a durable power of attorney. This allows the child who holds the power, that is the attorney in fact, that's what you call the person, to handle your finances during your life, including if you become unable to handle them yourself. So similar to the revocable living trust. The power can be as broad or as narrow as you want, but the child does not own your assets during your life. The power ceases at your death, and then the asset would pass under your will or by transfer on death if you have designated that, so that the asset is divided among all your children equally. So my first thought is consider the effect on your whole estate plan when you're designating beneficiaries and make your designations accordingly. Now, along with beneficiary designations, another really big decision in estate planning is who should have control of your finances when they were acting as your attorney in fact, that is the person who holds the power of attorney, your trustee, or your executor. Unfortunately, financial abuse of elders seems to be getting more and more prevalent. One study found that major financial exploitation was self-reported at a rate of 41 elders per 1,000 surveyed. This was higher than self-reported rates of other types of abuse, such as emotional, physical, or maybe neglect. Seniors lose at least $2.6 billion a year due to financial abuse, possibly more because a lot of it goes unreported, we're sure. Now, you might think that most of the perpetrators are usually caretakers, financial planners, attorneys, or other non-relatives. Not necessarily. There was a study of over 4,000 older adults, and the most common perpetrators of financial exploitation of older adults was family members at nearly 60%. Second, friends and neighbors, nearly 17%, followed by home care aides at nearly 15%. There are some risk factors associated with the people in each of these categories, such as they may have substance abuse issues or financial issues of their own, but sometimes it appears that they take someone's money because they can and they think they can get away with it, and sometimes they do. Another consideration to take into account for choosing someone to handle your financial affairs is the time and resources it's going to take to handle them. So you might want to review how long it takes you to handle your own finances and then add in some amount of time for someone who doesn't know your system like you do. It may be a job in itself for the person you choose. Consider then whether your children, relatives, or friends are really the best choice to have control of your finances, either during your life or to settle your estate. Would it be better to name a professional trustee and/or executor? People often don't even consider professional trustees, such as banks or trust companies, because they charge fees. So as Sally mentioned, I used to work in a bank trust department, and I know that banks and other professional trustees charge, and I know that sometimes it can seem like a lot. However, it might actually cost you less to name a bank or other professional as your trustee or your successor trustee when you become unable to handle your own affairs, or as your executor to sell your estate. And here's why. Trust departments have schedules of their fees that are easily obtained, so you will have an idea of what they charge. I mean, the fees may go up by the time that you need them, but you will at least have an idea. Individuals are allowed to charge for their services too, but most jurisdictions don't have fee schedules or even guidelines like from the probate court or anything like that. Trusts and trustees are not usually overseen by probate courts, so individuals can often charge pretty much what they want, subject to the market, if you will, and complaints by the beneficiaries. If beneficiaries do complain, your estate might land in court with your beneficiaries quarreling with each other and perhaps spending your money on litigation. So that's why it might end up costing you or your estate more than with an individual than with a professional. So when might you consider a professional trustee or executor? First, when you have no children, or you have no close relatives, or your friends are really not willing or able. Another time you might consider is when you do have children, or you have close relatives or other folks, but sometimes they just don't get along, or maybe they don't get along ever, and they have financial or other problems of their own. Another time might be when you have a blended family, especially if the spouses have a prenuptial agreement that has certain things in it that need to be followed to the letter. When you have unusual assets, you might consider someone that or a professional trustee because they might require more skill or expertise, like if you have property in another country. And of course, there's the wonderful catch-all, other reasons, which includes the trustworthiness of people who you might consider, so in general. Some people are concerned that banks or trust companies as their trustee will be too impersonal, and I understand that. You can certainly remedy that by giving a power of attorney to individuals to handle your affairs other than your financial ones, and then they would work with the bank trustee to do what's in your best interest. So as you consider who you might handle your finances when you become unable, or for when you want to have someone handle them after your death, I think it's best to do some research. If you're considering individuals, well, you probably have some firsthand knowledge of how they handle finances. If you don't, or even if you do, you might want to just talk to them about this sort of thing, this activity, this fiduciary responsibility in some detail, asking them how they would handle their own finances maybe, and other questions. If you are considering a bank, you might think about the bank that you do your retail business in. However, trust departments are different than the retail side of the bank, so consider interviewing a trust officer there. You might end up actually having building a relationship too, which is a good thing in terms of someone handling your affairs. And then for anybody, for whether you choose an individual or a bank or whoever, you might also list some expectations for whoever that future trustee is going to be and see if they can meet them. So what I'm thinking of, or sometimes people write down what their values are and what sorts of things they expect because of those values. My thought number 2 then is to carefully choose who will be in charge of your finances. If you know you can rely on an individual such as your child or a relative or a friend and it won't be too much of a burden, that's probably a great choice. But if you have any doubts, then you might consider talking to a bank or trust company to name them as trustee. Returning to the idea of designating beneficiaries, what about including charities in your estate plan? How can you be sure that your wishes will be followed once the charity receives your bequest or trust distribution? Sorry, got a little ahead there. It's best to work with the charity during your life to get your wishes documented and agreed to by that charity. If you don't have the charity's input, then what happens? They might not be able to follow your wishes, right? And then what happens? Well, the charity might have to ask a probate court for guidance. For example, using your bequest for a purpose as close as possible to your expressed wishes, but not exactly. Still, getting as close as possible in order to make the bequest useful. That's called a cypre action. Some of you have heard of that. Alternatively, I almost hate to mention this, but sometimes charities have to just decline the bequest because they're not able to use them exactly the way that the donor expressed the wishes in their bequest or other document. At the University of Michigan, we have a procedure where we work with donors to document the purpose of their bequests so we know what to do when we receive them. We typically recommend that your will, trust, beneficiary designation name us, the Regents of the University of Michigan, that's our legal name, and then reference an agreement between us. So this information and suggested language is on the university's plan giving website, and that will be in the chat. With your input, university plan giving officers write an agreement that expresses your wishes in a manner that is acceptable to you and to the university. The agreement's signed by both you and the university, so we all agree in writing. We like having an agreement between us instead of documenting everything in your will, your trust, or other instrument for a couple of reasons. First, we can include everything we both want in such an agreement. If you're talking about a designation from a retirement plan, then you probably know that you're limited by the number of characters, so you can't put very much in there other than the charity that things are going, your asset is going to. Secondly, an agreement can be changed by an easy amendment between us at any time or times during your life if your intentions change. And you don't have to make a codicil to your will or amend your trust. It's just an agreement between us. Then when we receive the proceeds, use them in accordance with the most recent agreement we have with you. If you want anonymity or limited recognition during your lifetime or after your death, we can usually accommodate that. Now, people often ask us, how do you know your wishes will be followed? How do I know my wishes will be followed, right? So you're probably not going to be surprised when I say this, but one good way to do that is to make a gift during a lifetime as a test. It doesn't have to be a big gift. Probably you want to intend it to be used immediately so that you can just see how things work, how the university processes everything. For example, some people make a gift for a scholarship that will be given to one student 1 year, and then they get to see who the university chooses and how everything works. They have a better idea in the end of what they will put in their bequest. So if you're not ready to make a lifetime gift, though, we'd like you to make your bequest as useful as possible. For example, you might direct that it be spent in its entirety. Or if it's to be permanently endowed, we'd like that purpose to be as broad as possible or provide alternatives in case the original purpose cannot be followed, because things do change. I'd like to say over time, but time is getting shorter and shorter, so things change. And I think most, if not all charities, and not just the University of Michigan, but all charities really appreciate that you avoid telling us how to administer the bequest. For example, instructing us to set up a committee to choose recipients or investing in a particular way. These restrictions can be costly and burdensome, and often because times change, they become outdated. So my third thought is, if you want to benefit charities, work with them to get your wishes documented and agreed to. Thank you for listening to my thoughts on estate planning. Now let's turn to your thoughts and questions that you might have.
Hi, Donna. So we have a few questions that came in. Some of the questions have been answered just by your presentation, so I'm not going to reiterate those at this point. But a couple of pretty involved questions, so let's just jump right in. One individual is considering a generation skipping IRA inheritance to grandchildren. When I hear generation skipping, I get nervous right away. But here's the rest of the question. Likely they would inherit in their early 20s. Is there a way for someone to have controls on that money so they don't waste it?
A trust might be a really good idea here. Making sure that the beneficiary is that person. There's certain types of trusts that you can set up. And as I mentioned, as one of my examples was the kind of 3 strikes you're out type of trust is what they call it, where the beneficiary gets a chance to sort of prove himself or herself over a number of years. It doesn't have to be 25, 30, 35. I just chose those because that seemed logical, but it could be 45, 50, 55, whatever. In any case, or forever. I mean, you can, there are ways to make a trust so that it stays in trust for quite a length of time, subject to, depending on state laws, subject to the rule against perpetuities, which I will not go into, but it's definitely a good question to ask your estate planning attorney because there are ways to do this.
Great, thank you. Another question, an individual is having a hard time finding legal expertise about IRA residual trusts. I wonder, he goes on to say it's a second marriage for both of them. They need the trustee to eliminate family dynamics after the death of the first of them. Might that be addressed by looking for an attorney at actech.org?
Mm-hmm. Right, yes, right. Yeah, that's definitely something that is very specific. So you definitely need a good estate planning attorney, someone who knows the different areas of the different parts of the law to get into that.
And as you mentioned already, the attorneys who are in that society are really the best. So
yeah, they are.
You can put there are drop-down menus. You can choose where you are, where you want your attorney to be. So it's very user-friendly, that website.
Mm-hmm.
Another question, what are the advantages and disadvantages of a ladybird trust or term when the when passing income at death?
I am not familiar with ladybird. I have to admit that is not something that I have kept up on. So I'm sorry.
I have heard of ladybird provisions in estate plans. You can probably Google for a little bit of information, but by all means, for the individual that asked that question, if you wish to follow up with us later, we might be able to help find at least a good description of that. So another question for you. Check our time because we're getting a lot of questions, which is a good thing. We do not have any dependents, but would like to designate beneficiaries of siblings and other relatives. What is a resource to determine the best, most fair way to designate who gets what?
That's really a very personal question. I mean, I can say to the person that I actually just went through this myself, and it took me a long time to figure out. I don't know what resource, other than you have to look and see what your goal is. Why are you benefiting these people? What do you hope that they might get out of it? Although once you give a gift to anyone, you cannot control that. You cannot see how it, you can't follow through and say, oh, you must use it this way. That's not what a gift is about, right? You give it to a person, and if they spend it all, that's unfortunate, but that's how the law works. So I would just say that that's a very personal decision, and you might want, again, to look at your values and what you're trying to do with this beneficiaries.
Yes. Let's see, another question. What is the most efficient way to make a charitable bequest through a trust? Can the trust beneficiary designate a designation be brief regarding, for example, the Regents of the University of Michigan and an amount, with the details, department intended use, left to the agreement between the university and the individual, or should more detail be included in the trust or will documents? You sort of referred to this a little bit in your
right. So that's what I was talking about. In the way we like to see it done is, in fact, have the trust say that it's to the Regents of the University of Michigan to be used in accordance with the most recent agreement on file with the university, or something like that. But the language is on that website that is in the chat. And then we can put detail about exact use and what the area of the university is into the memorandum of agreement. In fact, we like that. We'd like to know what college or school is, or whatever unit, part of, I shouldn't just limit to college or school, but what unit within the university should be getting the distribution, and then what your expectations are for the use of it.
Yes. Another question for you. You mentioned that state law would control certain distributions. Would a designation payable on death or payable on death to a trust pass without probate supervision?
Yes. So payable on death is a type of transfer on death. I probably should have mentioned that. It's typically, that term is used more for checking accounts and not so much other types of assets, but again, terms differ from state to state. So I just use the general transfer on death term when I was talking. Yes, you can make your asset payable on death to a trust, and that is a beneficiary designation that will pass directly to the trust without going through probate, subject to whatever your state laws are about creditors' rights.
Okay. If one of your beneficiaries lives outside of the country, but is a US citizen, are there consequences to that? Or anything else to consider?
It may be, depending on what kind of assets that you're sending to the person and where they are, then it may be a little more difficult to actually physically transfer the assets. Sometimes our financial institutions don't even want to transfer assets domestically, let alone to another country. But otherwise, the fact that this person is a beneficiary and is a US citizen is a good thing. So US laws should, and state laws should, cover that person in the typical way, if you will, and not because there are special laws about people who are not citizens and what they're allowed to get, or maybe I should say there's tax laws about bequests and trust distributions to non-US citizens. So if we're talking about a US citizen, the US federal and state laws and our state laws would apply.
Circling back to one of the questions from earlier about the generation skipping tax, and I said that makes me nervous. So the individual came back and asked, why do I get nervous? There are a lot of rules around generation skipping gifts. There are excise taxes that can be very onerous. If you are thinking about a gift that skips a generation, I would highly recommend that you speak to your attorney to make sure that you are aware of kind of the rules and possible consequences.
Right. For one thing, there's 3 different types of generation skipping. So you need to make sure you're in the right type, and you have the consequences of the taxes to go with it.
Goodness, so many questions. If we don't get to all of the questions, by all means, we'll have our contact information for the Office of Planned Giving at the end and in a follow-up email. So by all means, reach out if we don't get to your question. This is a question I think I can answer. Does U of M plan giving procedure allow for gifting from a donor advised fund both before and after death? By all means, the university accepts gifts from donor advised funds. We welcome them. Thank you very much for thinking of us. Some donor advised funds, individuals are able to name a beneficiary if there are funds remaining in the DAF when the donor and then typically one generation can control those funds. But I think that might be particular to the donor advised fund itself. So you may want to check with the organization that holds your DAF to ask if you have the ability to name an ultimate beneficiary of those funds. Did you want to add anything to that, Donna?
No.
Okay. Copyrights, trademarks, and patents. This individual has that he would like to leave to someone or something. Is there a resource available to help me decide what direction to send these?
It probably depends on what they are. So if it's something book related, there's probably a resource specifically through libraries about that. I know our library, when taking certain types of works, will ask you, do you want to give us the copyright or not? And so, we work with that. Yeah, so I don't know of any one particular resource, but I definitely look at whatever the particular asset is and research from there what associations there are that might be able to answer that.
Great. Another question. If a gift is made to Michigan from a retirement plan directly to the university, the retirement plan permits such a donation, can personal taxes be avoided regardless of the amount of the charitable gift to the university?
Yes, so that would be both during life and after death. I don't think they said, right?
It did not say if it's during lifetime or after death.
Yes, so there is a lifetime, well, during life, there's an opportunity for certain folks to make a charitable, well, Sally knows the terms better than me, charitable rollover gift.
We call it a qualified charitable distribution.
That's it, right. And her office can handle everything in that respect. If you're not eligible for that, you can still take a distribution and then make equal amount as a charitable gift, and the tax should hopefully come out as a wash. It might not, you'd have to figure it out. After death, it's always any assets can be given to charity, including retirement plan monies. And it's a charitable deduction against any estate taxes you might have at the federal level. And I believe that is true of every state if there are any state taxes. But, caveat, you'd have to check your own state to find that out for sure. It's definitely true in Michigan. So
we have a couple of questions about restricting usage of a bequest designated around campus. So a question about Michigan marching band.
That's a yes, right?
Yes, it is. I was going to lump all of these together.
Oh, okay.
A question about scholarship for need-based undergraduates. Yes, and this is what Donna referred to as we like to have an agreement. I mean, we are happy to know how you would like us to use your gift in the future. People designate their gifts to every nook and cranny around campus, and I I am confident in saying that those areas are more than happy to have your support. So here's a question. The things do change and can significantly change charitable planning. So, extraordinary residential or care. My intended asset source for a gift to the law school, thank you, could be exhausted by unexpected and long-term spending. Yes, occasionally we do see situations like that, but sometimes people want to spend all their assets traveling around the world, and we understand that too. So I suppose I know the answer to this. Do charities prefer that a particular amount of a bequest be specified? Or can a trust designate a percentage of the trust assets for a charity, which would allow for gifts to be better synchronized with the financial situation of the giver as they age? Yes, you want to speak to that a little bit, Donna?
We sort of take anything.
Yeah, and I think that I wonder if I maybe
I should, sorry, qualify anything of a specific amount versus percentage or residual. Either of those are, any of those are fine.
Yes, and sometimes I feel like, and I don't want to be offering legal advice without a license, but if I designate everything in my estate plan by percentage, it sort of holds everything kind of equal, whether my assets go up or down, rather than specifying a dollar amount that could be locked in while some other things change within your estate plan, right?
Yes, that's true. However, there are times when you might want to just say, okay, I want to leave X amount and then I'm done. So both sides of the coin.
Yeah, I think you addressed this a little bit during your discussion as well. Advice about how to split assets between two children who have markedly different financial success in life.
Actually, I didn't really talk about that. I think that's a tough one. It's certainly an individual decision. Are you, do you want to just say, okay, I want to benefit one more than the other because one needed more? Or would you rather just say, I had two children, so they each get half? That's a tough one. I don't really know how to say that other than to say that that's a very individual decision.
Yeah, very much so.
I will say one thing about it though, and that's that in my experience, it's really not a bad idea to talk to the children and see what they think. Yeah. Because sometimes the one who's financially better off will say, you don't have to leave me anything or just some nominal amount. Let's help, sibling. Or they might say, oh, I expect to get my share and I'll be mad if I don't. So, talking to them always helps.
Yes, indeed. Yeah, I think in some cases it's wise for them to know before we pass away what we've kind of planned.
In most cases, people
Yes.
have expectations.
Yeah.
Children have expectations, so find out what they are.
Yeah. Please address the revocable trust options and designating U of M, a U of M gift as a restrictive gift. What may be the best type of irrevocable trust?
So there's different types of irrevocable trust. There's one that's for life insurance, but I'm guessing that since you mentioned the U of M gift, you're talking more about a charitable trust that's irrevocable, what we call a charitable remainder trust. And you can certainly write up or have an attorney draft a charitable remainder trust. We can actually help with that, by the way, because the university is trustee of a number of charitable remainder trusts where we are the beneficiary. And Sally would be glad to tell you what all the rules are about that. They're also on the Plan Giving website as to when we would act as trustee. But in any case, even if you don't want us to be trustee, you can have an attorney draft a charitable remainder trust that gives income to an individual or individuals during their lives or for a term, and then goes on to charity. There's also something called a charitable lead trust that's also irrevocable, and that's exactly the reverse. So income or some annuity goes to charity for a term, and then the rest goes to individuals. So good questions to ask about your attorney. We certainly are glad to be a beneficiary of any of those.
Yes. One person has written in that life was simple when there were not a lot of assets involved, but now he or she has inherited some items, and while feeling blessed and swamped, says need a roadmap to organize my assets and thinking. I think one good place to start might be a financial advisor.
I agree.
And then check the acttech.org for an attorney who can help sort of put some shape around thinking and best ideas for an estate plan.
Right, and just to emphasize or expand on that a little bit, there's at least two ways financial advisors charge. One is as a percentage when they are taking care of your assets, and the other one is fee-based, and which means they don't necessarily have to take care of your assets. They can, in fact, just advise you and charge you hourly for the advice that you're getting. Also, you might even consider an accountant and having an accountant help you kind of organize, because they have to do a lot of that sort of thing, and they're not just for tax work, they're also for helping to organize. So
we have time for one more question. And so someone has asked if there's a minimum donation that we need to make a planned gift. I would say that there are several answers to that question. It depends on what type of planned gift you'd like to arrange. If it's a life income gift, we do have minimum gift amounts that are required in order to establish those charitable gift annuity, charitable remainder trust. Happy to have that conversation with you. Any of my colleagues in the plan giving office would. And then it sort of depends on what you want to accomplish with your gift. There are minimum gifts required for endowed scholarships around campus, professorships, research funds. Again, happy to have that conversation with anybody who would like to chat more and learn a little bit more. So with that, I will wrap it up. I just want to say again, please be in touch with the Office of Plan Giving if you have questions that we can be helpful with. There's more information on our Plan Giving website, which is plangiving.umich.edu. We will send a follow-up email that'll have our contact information, and it's also on our website, the plangiving.umich.edu. So Donna, thank you so much for sharing your expertise today. We really appreciate it. We're happy that so many people from across the country were able to join us for this session today. And I just want to say thank you and go blue.